Please rise. Court is now in session.
I Strenuously Object, a legal podcast brought to you by the Pittsburgh law firm of Flaherty, Fardo, is now in session.
All those seeking information about the law and legal matters affecting the people of Pittsburgh and the Commonwealth of Pennsylvania, half-baked opinions, and a dose of self-indulgence are invited to attend and participate.
I want the truth! You can't handle the truth!
The defense strenuously objects.
You would!
Call the first witness.
All right, hello, greetings, and welcome once again to I Strenuously Object. It's a Pittsburgh legal podcast. My name is Bill Rogel, and I'm an attorney and a partner with the law firm Flaherty, Fardo, Rogel, and Amick, and I'm here by myself today. Noah's not joining us, but we'll try to soldier through, and I'll try to spare you too much monotonous droning on the part of my own voice. But I would like to speak a little bit today and talk about the idea of spousal privilege. Some of you out there may have heard of kind of this term or understand the concept a little bit, right? I can't think of specific examples offhand, but there are definitely movies or television properties where, you know, a criminal defendant gets married so that the person that they marry is no longer able to testify against them, those kind of things. And spousal privilege is a real thing. Now, I'm going to mostly talk about it in a civil as opposed to criminal context today, because that's what I do.
It's what I do.
On the other hand, you know, there are parallel rules that cover spousal privilege in the criminal world. They're a little bit different, you know, so I'm certainly not, nothing I say is legal advice here today anyway. We got to have a disclaimer of some kind.
Pay no attention to that man behind the curtain.
You know, a frankly more misogynistic time where generally it was, you know, there were some issues with recognizing the full personhood of a wife, you know, and her ability to act as an independent agent and fact witness. And it's been criticized accordingly, right? That, you know, your wife should be allowed to speak against you if she wants to speak against you, and you're not supposed to be able to cordon this off. She's not your property. You don't get to talk to her and say what you want and then have her bang zoom. And those criticisms are fair and have kind of circumscribed the privilege a little bit, but it still exists. It's still real. And of course it works both ways or all ways now, right? It is it is spouse, right? Your husband or your wife is not allowed to testify against you or confidential communications made within that. So while the history of it may not be particularly egalitarian, it does apply equally in these regards. Okay. Again, two privileges. One of them is confidential communication. One of them is spousal testimonial privilege. I'll handle them in that order. So confidential communications, it's kind of like other privileges you may know about, whether it's an attorney-client privilege or priest and penitent privilege.
Tell me your sins, my son.
Well, I should mention that I'm Jewish.
Well, that's no sin.
Things that you say under certain circumstances, the person you say them to is not allowed to disclose those things. Statements you make for psychiatric care are often protected in the same way.
You are very good.
There's a lot more to it than that.
You're very good, you.
There are lots of places where, from a public policy perspective, the ability to communicate within a particular kind of relationship is sufficiently important that it actually trumps our ability, our desire and our policy in figuring out the truth in a civil case. And that's certainly the case with some of the best evidence you could theoretically find because a person's being honest are things they say in these kind of confidential contexts where they think what they say can't be used against them. But we want people to be able to do that. We want husbands and wives to be able to all speak, spouses to talk to each other and not worry that the thing I tell my spouse at night will someday be used against me in a court of law. And so confidential communications that are made within the context of a married couple are privileged, protected from disclosure. It can be waived. Like any privilege, it can be waived. Things that you say to your spouse where a third party can hear you are not going to be privileged because there are other ears there. You don't have a reasonable expectation of confidentiality.
You've got big ears.
Statements that are made to a romantic partner who is not your spouse are not protected. You know, I do not have the same interest and the same confidentiality in speaking to, you know, a boyfriend or a girlfriend, an ex-spouse, or, you know, anyone other than a communication that's made within the confines of a legally recognized marriage. Again, there are other privileges, right? So if my psychiatric provider is also my spouse. The fact that I'm not married doesn't mean that I don't have some other privilege to invoke. But it is important to note that statements I make to my fiance.
I have lost my fiance, the poor baby.
Maybe the dingo ate your baby.
Statements I make to my fiance before I'm married to that person are not protected. The fact that I subsequently married them doesn't go back in time to turn that into a protected confidential communication.
Go back in time, okay?
No going back in time.
The other thing to note is they can be relatively easily waived by either party. If a spouse wants to testify about confidential communications that I made, I can't stop that spouse, right? If I'm on trial and my wife wants to come into court and testify about a thing that I told her that has some bearing, I do not have the legal right to stop her from speaking against me in that regard. So anyway, that's spousal communications privilege, and it covers narrowly only confidential communications, things that I say. So not how I look. If I came home the day after an accident and I seemed shaken up or guilty, or, if my spouse overhears me on the telephone and I tell someone else something, none of that stuff is covered by spousal communications privilege, because that wasn't me talking to my spouse. My spouse is allowed to testify and can be asked to testify generally about non-communications, and that can include gestures or emotional reactions or facts, right? My spouse can testify. It's not spousal communication privilege for my spouse to say, oh yeah, he had that car and then I saw him drive away and I never saw that car again. I don't know what he did with it. That's not a communication. So that's not protected. Now, there is a second privilege, and that privilege is spousal testimonial privilege. And the rule is written basically, a husband or a wife is not competent to testify against the other. Period, full stop, right? Unless it's waived. Against can do a lot of tricky legwork here. So we had a case, for example, where we had filed a lawsuit against both a husband and a wife. We were allowed to depose the wife in her own case, right? She's a defendant. I get to take her deposition. The spouse doesn't get to stop me from taking her deposition just because what she says could be harmful to this spouse. It's actually kind of interesting to think about that in terms of the unintended consequences of the rule of the spousal testimonial privilege. Is it creates an incentive to sue both parties, both spouses, so that you can still hear from the one.
Who did this to me? Who can I sue?
But this is one where, honestly, I'm not sure. I've encountered some attorneys who I don't think recognize that there are these two different privileges and that they apply differently, but generally speaking, if, say, I'm the defendant in a lawsuit and someone sues me, even if it's only to talk about simple facts, what time did he leave the house that day? What time did he come home? How did he seem when he came home? Have you seen this knife before, right? And whether it's criminal or a civil perspective, it's stabbing someone is a lawsuit too. You just don't usually get stabbed by someone rich enough to sue them.
Hey, easy with that. That's my lucky stabbing hat.
Say your husband comes home, or your wife, and they're covered in blood, splattered with blood. And they say, I don't want to talk about it. And they go clean up. They never mention a thing to you.
This? No. I was at a costume party earlier this evening.
You find out the next day that your neighbor was stabbed, either injured or to death, doesn't really matter, but they were attacked by someone with a knife. You have not had a conversation with your spouse about this thing. Does spousal privilege still apply here?
Well, yeah, I mean, and that's why I want to stress there are two different privileges. That is not covered by spousal communication privilege because it's not a communication. It may still be covered by spousal testimonial privilege, where the other side simply cannot call you as a witness at all. Any of these facts, which are clearly not covered by spousal communication privilege, nevertheless, the other side cannot call my spouse to testify against me, even about facts that have nothing to do with any kind of confidential communications. Just not allowed to call my wife as a witness against me, period, full stop. Now, again, against can be a little bit tricky. I think the best reading is, well, look, first, the other side cannot call them as a witness. If I'm not volunteering them as a witness, if you're calling them, that's against me, right? That's a hostile witness kind of situation. I can file a motion for a protective order to stop it. So, the spousal confidential communication privilege applies at the time of the confidential communications, right? So if I spoke to someone who is my wife before we were married, those communications aren't privileged. if I spoke to them while we were married, but we've since divorced, I had the expectation at the time I made those communications that they were privileged, and so it's still protected.
I'm a manufacturer. I'm not a dealer, per se.
No, Skyler.
Spousal testimonial privilege is different in that what matters is at the moment they're called as a witness, are they your spouse? So if I made communications with my fiance and then got married and we're still married, while communication privilege won't apply, testimonial privilege will, and you can't talk to my wife anyway. Now, if we get divorced subsequently, then I have no protection whatsoever. Communication privilege will still apply to any communications that were made while we were still married, but spousal testimonial privilege does not apply to anyone other than someone who is currently, at the moment they're being called as a witness, your spouse. And again, both these privileges can be waived, and frequently are, right? In a lot of personal injury actions, we want to talk to the spouse. You know, we want to hear from your husband and wife about how your life was changed and what it was like when you were in the hospital and what your recovery was like when you got home. And even today, all of the, you know, the difficulties that they still see you facing day to day. You know, we don't want to invoke privilege and keep that testimony out. We want to hear that testimony. And so we don't invoke spousal testimonial privilege. We may or may not decide to still try to protect with respect to spousal communications. It's kind of a case-by-case thing. So, I mean, in that context, you're often going to want to hear from a spouse. But theoretically, you know, if you don't want your spouse to testify against you, you do have the ability to invoke that privilege to try to stop it. Now, in most of these cases, and this is the thing I do want to close on, I don't want to speak out of turn. I haven't researched this issue like all the way down to the bottom of the depths, right? I could be wrong.
I'm sorry, what?
Don't use that against me later. So my wife's going to save a clip of that and just play it at me again and again and again, right? I could be wrong. I could be wrong. I could be wrong. Generally speaking, both spouses have to want the protection of the privilege for the protection to apply. I can't stop my wife from speaking about confidential communications. I can't stop my wife from choosing to come in and testify against me.
Shut up! Shut up!
And this may not have been the way it was as it developed at common law, right? But now, recognizing that, and there's a bunch of exceptions that are baked into the rule anyway. A lot of family law contexts, right, where obviously a spouse is able to testify. The testimonial privilege does not apply in PFA situations or, you know, child support or custody discussions and those sorts of things. There's a lot of family law contexts where obviously the ability for an abuser to use the privilege to cover up and protect themselves from accountability for their abuse, it could be used. And the law has mostly tried to back away from that and make sure that can't be the case. Never say never. I'm sure there are still some particular times where it can kind of frustrate that purpose. But generally speaking, like any other testimonial privilege or any other communication privilege, if someone goes out and blabs to the neighbor about the thing, privilege is waived now. Like, it's no longer confidential. If you make a statement that you think is confidential, you have to trust the person you're speaking to.
Do you trust your wife? Oh, that's funny.
That they're going to keep it confidential, because once they go out and start talking about the thing that you said, confidentiality isn't going to apply anyway. In the context of attorneys or, you know, psychiatrists, there are rules of professional conduct that also step in to tell them, hey, you're not allowed to go tell someone else this thing that was said to you in confidence. In the world of spousal privilege, it's not a thing. It's not illegal for my spouse to go out and betray that confidence by talking to her friends, her family, strangers, opposing counsel, whoever she wants to talk to about what confidential communication I said. The privilege can be waived even if I, as the defendant, want to protect it. Sorry, if my spouse has already waived it by saying the thing, you know, that horse is out of the barn, or toothpaste is out of the tube, or cat's out of the bag.
Cat is out of the bag.
There's lots of things that escape that we can't put back in that become metaphors, and all of them apply here. So, all right, thank you for joining us on this episode of I Strenuously Object. Please subscribe, rate, review the podcast. It helps other people find us, which is hopefully a thing we want to happen. Tell your friends, check us out. If you have any questions for a mailing it in segment or any other feedback for the podcast, we have a podcast-specific email address. That address is iobject@pghfirm.com. We're on Instagram at I Strenuously Object Podcast. For any legal information or questions that you may have, visit the website, our website, Flaherty Fardo's website at pghfirm.com. Until next time, some parting advice.
I mean, what are you thinking about, Jerry? Marriage? Family?
Well,
they're prisons. Man-made prisons. You're doing time. You get up in the morning, she's there. You go to sleep at night, she's there. Yeah, and you can forget about watching TV while you're eating. Because it's dinner time. And you know what you do at dinner?
What? You talk about your day. How was your day today? Did you have a good day today or a bad day today? Well, what kind of day was it? Well, I don't know. How about you? How was your day?
Boy, it's sad, Jerry. It's a sad state of affairs.
I'm glad we had this talk.
Oh, you have no idea.